very word secrecy is repugnant in a free and open society, and we are, as a people, inherently and historically opposed to secret societies, to secret oaths, and to secret proceedings. We decided long ago that the dangers of excessive and unwarranted concealment of pertinent facts far outweighed the dangers which are cited to justify it.
Okay.
Even today,
I have read the briefing, and then let's start with the argument on 59 and 60 motions, which I don't want to say they're identical in every sense of the word, but they're substantially quite similar, and I know the 60 was filed as an alternative in the event that the 59 was deemed untimely. So, Mr. Risner, would you like to argue on both of those motions, if you would?
Well, yeah, I'm certainly willing to do that. I will be putting on testimony related to the setting aside your ruling, because I think the facts inform whether or not the motion should be granted. But the 60C grounds refer to several issues. One is fraud, misstatements, the court or the counsel, intrinsic or extrinsic, misrepresentation, or other misconduct, or any other reason justifying relief. The trial in this case was on July 23, and the court ruled based on what was presented on July 23. And procedurally, what happened was the Judge Lee initially had granted plaintiff the ability to take a couple of depositions. The defendants filed a motion for protective order saying that they would like depositions to be canceled because they had turned over all the documents. And that was put in a motion for protective order filed on July 8th. So the depositions were canceled. At this hearing, again, the defendants said that all the documents had been turned over, that the only thing we were fighting about, that all the remaining documents were sealed in envelopes and couldn't even be described, but the city would show why those things shouldn't be turned over. And at that time, there were fewer than 200, quite a bit less. But let's, in round numbers, let's say less than 200 sheets of paper. In the latest filing, the city defendants, not just the city, but the three defendants, claimed that they've now turned over 2,700 sheets of paper. So there's 2,500 that have been turned over after the trial. And I'd like to back up just one little bit. In the motion for a new trial and the supplemental motion for a new trial that was argued, I believe, in October.
It's the August 27 motion, right?
Yeah.
I think that's late August is when you filed.
Right.
Okay.
So what we saw as a pattern there was the Friday afternoon before the Monday hearing, the city mailed what they claimed was all the stuff, 800 pages. So then we were in here arguing before Your Honor, and again in round numbers more or less, because there had been some documents turned over after July 23. At that point, there was maybe 1,200 pages. Now we've had an additional 1,300 pages. So the distance between the 2,300 pages and what was there before is a rather remarkable distance. But what we've really got so far is kind of a discovery dump, where they have given us a lot of pages, but the key information, the heart of what was needed by the plaintiff and what we're concerned with, has not yet been turned over. And that is the key reason of why this thing needs to be reopened. We will be offering testimony. There was a motion, a 30B6 deposition, that the city didn't provide people to testify about lots of issues in that 30B6. But what they did produce on a key question, the key question was, what had the city done and prior to July 23, prior to the order to show cause here? So there were two witnesses that could have spoken. One was the IT department. The IT department says no involvement. No one asked us for any documents. We weren't involved before July, and in fact, they said they had some involvement in September, and they weren't prepared to say what they were exactly asked to look for even then. Mr. Casalimas testified, and this is really the very critical aspects. Casalimas' testimony, and we have email to back this up, was that when Cecilia Cruz delivered her request on May 13th, that same day it went to the manager's office. The clerk said, accumulate these documents and provide them directly to the requester. The next day, oops, cheat. Now provide these to the city attorney's office. So Mr. Casalimas said, pretty much immediately afterwards, he met with Dennis McLaughlin from the city attorney's office, who says, we're in charge of accumulating all these documents. And he turned over his hard copy files to Mr. McLaughlin, and he said that he knew, this is the city's testimony, that the same requests were made of other people. And he said it's the kind of, you keep in these hard copy files the kind of information that is involved in a project like this. So this last weekend, prior to the Monday hearing, we get some more documents in the city, which have some more individuals involved.
This immediately preceding weekend?
Yes.
Okay, so 3 days before now?
Yes.
Okay.
Yeah. So,
How many pages?
oh, I don't really know.
Here's, if we can have it marked.
Yeah,
Okay, well,
This is,
yeah, why don't we can mark it when we get to our argument, all right.
and
okay.
there's a lot more that he's not telling you.
Well, Mr. McLaughlin, you will have the opportunity to respond, so please refrain from
Thank
what I
you.
think is a gratuitous argument there.
Thank you. I apologize, Your Honor.
Okay, Judge. One of the key categories, and in fact, I think in Ms. Cruz you know, what she requested, first thing was all hard copy documents. So we weren't provided prior to July 23 any hard copy documents from files. And same thing today. We have nothing from Richard Miranda, the city attorney. Casalenas testified he reported to Miranda. Nothing from his file. Albert Elias, who was in charge of this, we didn't get his hard copy files. Nor Chris Casalenas. What we're told is, and Chris testified that he met with McLaughlin and turned it all over. Attached to one of our motions as an exhibit is the letter from Mr. McLaughlin saying, well, yes, Casalenas testified that he gave me that, and I can't find it. But if I ever find it, we'll let you know and we'll turn it over. Nicole Ian Gavin, Rebecca Wade, Tim Murphy, Jim Rossi, Marcella Solis, Kelly Gottschalk, Liz Miller, Ernie Duarte, Camilla Beckett, Andrew Squire, Mike Sikowski, John Padres, Mayor. There's no hard copy file from any single person. The request, we wanted to know about agendas of meetings. The plaintiff worked and is retired from the city, 20 years, 2 years in the city manager's office. They have agendas. To date, we've received no agendas. At meetings, people take notes. To date, no notes. Meetings appear on calendars. To date, no calendars. Now, Ms. Cruz did make, after the July 23 hearing, a request for the notes with Hector Martinez, the real estate guy from the city, because we had testimony from Casalenas that, well, he didn't get anything, he didn't think he got anything in writing from Hector Martinez. Well, since there was a city ordinance that would require a evaluation, we asked for that in the notes, and so we have some from Hector Martinez. I believe he's the only one that we have notes from. Now, it could be that the city may say, gee, in our, the way we do business in the city, nobody takes notes. We don't do agendas. We just like keep this stuff in our head. That's not the way we understand city practice. And what we want is this thing to be open, to be able to ask the individuals directly. We've had a real problem in this case where the representative of the city, and the city, I want to be clear that it's my belief that the lawyers represent clients. We sued the city manager because it was his office and he was in charge of the project. We sued the city clerk because it's his job to be in charge of documents under the city charter. And then the mayor and council filed an answer where the city became a defendant. But my blame is not on their representative in court. My blame in this case is on the city of Tucson, the manager, clerk, mayor, and council, the city. They understand these issues in this case. Before, we'll have evidence before my client sent in her public records request that she wrote. This was nothing by counsel. The same questions basically she asked, Steve Kozachik asked it. Who's responsible for this? Who's driving this thing? What are the issues? The stuff he wanted to know in the week before Cecilia Cruz, the same stuff that she wanted to know. And yet, all of that information that was in the office, we have nobody's hard copy files, none of the agendas, none of the notes from the meetings that would let the public, and in this case, you know, as I mentioned before, we certainly have a single citizen who signed that. But as she testified, she's the representative of a coalition that includes the neighborhood group next to this large park that's the first park ever sold.
That's in your briefing, yeah.
Yes. So the city of Tucson understands, and they understand that the law requires prompt disclosure. It's by statute. They understand politically that political issues that are on the plate, that the public could use that details and could use that information in a manner that is prompt. But we're here not just because of, certainly lots of these things add up to defenses that aren't meritorious. They add up to things that aren't in good faith. And those things are relevant certainly to attorney's fees. But what my client wants, and as a lawyer, what I want for my client, is to get the records that the law says must be provided pursuant to the public records laws. And even today, we don't have those. We have a stack, a big stack, but we don't have the key documents and the key information that, according to Mr. Casalemas, does exist, and similar information does exist, and the city began immediately accumulating after our request on May 13th, and they had until July 23 before the hearing.
What evidence do you propose to present today?
Well, I propose to present Cecilia Cruz, who would describe her background, how she understands what the policies are in the city manager's office, because she worked there, how they do the meetings, the agendas, what information should be available, at what point she sought the assistance of counsel when they weren't, that information wasn't provided, that all the information that is, that she's aware of, those giant categories that are missing. She will, it's an interesting thing. May 20th, she met with the city manager and Albert Elias' assistant, Kelly Gottschalk, on behalf of the neighborhood. They wanted to talk about what's going on. And they were told by each of those people on May 20th they couldn't talk because of a confidentiality agreement. We will offer an email that says that 3 months previously, TREO sent over and said, Grand Canyon releases you from the confidentiality agreement.
That evidence came in during the July 23 trial?
No.
Didn't it?
No.
Well, I knew they were released from it at some point, and I would have learned that in the July 23 trial.
Well,
But in any event,
no, what you learned and what I learned, because there's no discovery in the July 23, is there was a May 16th letter, and maybe there's a press conference that's going to affect whether they're going to be released. What we didn't know until this weekend, I believe, was that on February 20th, there was specific emails saying you're released, but 3 months later, the neighbors weren't told. You'll hear from Tina Pacheco about her attempts to get through this maze and to keep track of how things were released and the manner of what the city would release, a few documents here, no attachments, no references, made it extremely difficult to follow, and what's not there. You'll hear some of that testimony from her. I have deposition testimony from the 36 from the IT department, from Casalemas.
Do you have clean, full transcripts of those depositions?
Yes, I absolutely do.
All right, well, now, let me hear from Mr. McLaughlin, and I'll come back to you, Mr. Risner. Well, actually, wait a minute, Mr. Risner, before I hear from you, Mr. McLaughlin, I understand the argument you're making. When does the case end? That's one question. You don't have to answer it right now. I'm gonna come back to you. When does the case end, and how do you know it ends? Because,
You want to answer now?
well, and aren't you really asking for ongoing management of a record search by the court? Isn't that really what you're asking for? You want to answer those now?
Sure.
Sure, okay.
Yeah. No, I am not asking for ongoing management by the court. In fact, there's been a bit of a problem in this case because the court managed and said no discovery, and that created a bit of a problem. But look, a public records request is mandatory that they turn over the records. The case ends when they turn over the records.
How do you know?
How do I know?
How do you know they've turned over all the records?
Well, that is a problem. And it's a problem because a good part of the system relies on the good faith of the agencies. In fact, the case law says they're required to make a good faith search. So it's not been in good faith. They didn't make a good faith search, and they didn't turn over the documents in good faith. That increases our problem and why we need to take depositions and ask people, what was in your file? When did you turn it over? Because my experience is those people all won't lie, and we'll be able to find out what happened. But we can't be in court where the defendants send in someone or say, we've turned everything over. Now we've turned everything over. Now we've turned everything over. And that's, oh, now we've turned everything over. The right to know what's going on in these public offices is important. And believe me, you asked the first time we're here, wow, this lawsuit was filed in May, and yet the hearing was set in July. We're not in pushing them, demand them to do stuff. They had plenty of time to do it. But it cannot be, and you would, the court would be harming the public interest if you could say, well, when we have a hearing and the city doesn't play fair and the city isn't honest about it, well, I guess they win and we talk about attorney's fees. It can only end when they do what they're supposed to do, and we need to have the ability to find out what it is that was there and what they didn't turn over. And we know these huge categories. They haven't done it.
Okay, thank you, Mr. Risner. Mr. McLaughlin, before